Welcome to Zaasakwe's online radio, Intertribal News. This week, on our first podcast, we speak with Chief Isadore regarding a Supreme Court decision regarding a pipeline, and we talk with Russ Dabo and the Union of Ontario Indians with their Anishinabek education policy, and get another perspective from Russ Dabo himself. And we speak with and Freda Houston of the Unistoten campus. You're listening to Zaasakwe Online Radio.
My name is Tracy ODonnell, and I'm from Red Rock Indian Band, and I'm the education negotiator for the Anishinabek Nation. And I negotiated this agreement with Canada together with the Anishinabek First Nation so that we could have better opportunities for Anishinabek students, whether attending school on reserve or off reserve. We also negotiated part of this arrangement post-secondary funding so that Anishinabek First Nations can be reassured that post-secondary funding will be available through these arrangements we negotiated with Canada. Okay, we've been getting a lot of questions about whether Aboriginal and treaty rights will be affected by signing on to this agreement, and we wrote right into this agreement that our Aboriginal and treaty rights will be protected. That means in legal terms there's going to be no abrogation or derogation. We're not going to give up or lose our rights by signing on to this agreement. Instead, what we're going to be doing is securing education funding for Anishinabek at levels that we have had input into, and we'll have this funding for all time for our students and our education system. Well, I just want to say this is a real opportunity for us as Anishinabek to take control of education. For over 40 years, the First Nations here have been saying Indian control of Indian education, and that's what this agreement is about. It's about Anishinabek taking control of education to ensure that we have the best opportunities for our students, whether they're going to school on reserve or off reserve, whether they live on reserve or off reserve. We have to do this for our future. We have an opportunity, and we should take it.
And now with Russ Dabo and his position on this self-government policy.
Here with this because I was one of the people who helped create the Aboriginal Liberal Commission in 1990. I was Vice President of Policy from 1990 to 94, so I was involved in developing the Liberal platform in their election in 1993, where they promised, to act as if the inherent right to self-government was in Section 35. So they promised that. But when they got into power, John Chrétien was the Prime Minister. He had the Minister of Indian Affairs, his buddy, Ron Irwin, as Minister of Indian Affairs. They introduced a policy without consulting First Nations called the Inherent Right Policy. But it's anything but an inherent right policy. That 1995 Aboriginal self-government policy says what's on the table and what's not on the table. And basically what it does is it sets out terms, that you can have local government, but all matters of national interest regarding trade and commerce and all that, they won't share those powers. Because Canada's first constitution back in 1867 divided powers between the federal and provincial government. And there was no room for First Nations in that constitution, the first one. That's why during the constitutional talks, the national Aboriginal organizations were arguing that Aboriginal government should be recognized as a distinct order of governments in the Constitution. Again, based on it. So different regional organizations and bands across the country have started negotiations, since the 1990s under that policy, and are agreeing to convert from being an Indian Act band to becoming basically like a federal ethnic municipality, because it's based on a harmonization of laws model where you have to harmonize First Nation laws with federal and provincial laws, which means you have to accept the federal and provincial orders of government and the federal and provincial laws. So basically you have delegated authority, for example, in education or other areas of provincial jurisdiction. Under that self-government policy, the provinces have a veto in areas that affect their heads of power, their areas of jurisdiction. So groups have agreed to compromise their Section 35 rights and go into these self-government agreements across the country. West Bank, for example, in British British Columbia agreed to do that in their area. And they're next to a city, so they were able to, use that self-government agreement to get hundreds of millions of dollars over the past number of years in collecting tax revenue from having big box stores net on their reserve. So they've been able to use that policy, I guess, to their advantage. But for most First Nations, compromising, you're basically surrendering to Crown sovereignty under that policy because it's not recognizing pre-existing sovereignty. My lawyer friends talk about the de facto sovereignty of the Crown. I like to say the asserted sovereignty of the Crown, but the fact is they have the police and the army if necessary, as we saw in 1990 with my own home community. They'll bring the army in if you go beyond what they're prepared to negotiate. They're implementing what I call a termination plan, where what they want to do is get consent from First Nations to agree to, convert or exchange or terminate their collective rights for new modern rights in these agreements, which are lesser rights than what we're entitled to, even by international human rights standards. Most groups are dependent on the federal government for financial transfers. And that's why you see, you refer to the education negotiations. There's a lot of money at stake there, and that's why most First Nations agreed to concede, surrender, compromise their position on sovereignty in exchange for some, program dollars entrenched in an agreement. And that's what they're getting at, negotiation programs and stuff. But the policy also says you have to raise own source revenue, so that's code for taxation. So that policy also has built in there that First Nations need to start taxing their own people.
Okay, now we go to Togastai and Freda Houston of Unistoten Captain and what they're doing to protect their territory and how they're asserting themselves by the rule of law.
I belong to the Govt clan, and we're better known as the Unistoten people, and I follow my mom's clan. So each time a woman has a child, that child belongs to your mother's clan. So the territory I am on right now, where our cabin is built, belongs to my people. So matrilineally, I have a right to be here, and my children have a right to use these, and my husband also has a right to use the territory as long as he's married to me. We have 5 clans, we have 5 territories, and the territory that we're currently living on is Unistoten territory, and as we cross over the bridge, becomes Gidimdan territory, and then further back on the territory, we'll go into Togastai territory. So all of the 5 clans are, where these proposed projects are proposed for, is for all 5 clans. But we're currently the only ones that have taken the stand and are actually living on the land to ensure that none of the project comes through here.
Cabinet we live in on the river crossing for the Enbridge pipeline project, and what they ended up doing after we built the cabin here and moved into it was they made an amendment to their pipeline proposal, and they moved the river crossing upstream from a half a kilometer to 2 kilometers. These are all 3 major pipelines that want to come through our traditional lands. And, Enbridge was like everybody wanted to focus on Enbridge. Everybody had to fight Enbridge. And we were busy fighting Enbridge and 2 fracking pipelines. Like Freda said, it was Pacific Trails Pipeline, which is the main group that's behind Pacific Trails is Chevron. And we have TransCanada's pipeline, the Coastal GasLink pipeline. And these 2 pipeline projects wanted to cross just upstream from where the Enbridge pipeline was. And for us, we don't want these so-called LNG pipeline projects in here because we've seen some of the agreements, the confidential agreements that they've signed with local communities, and these confidential agreements state right in the agreements that they plan on changing or converting these LNG pipelines to oil after 5 years. And that's something that's really concerning. They're not they're not selling these pipeline projects as oil pipelines. They're selling them as LNG pipelines so that the public will let them build them. But all they want to do is convert them over to oil as soon as they're constructed. So, yeah, there's no bloody way we're letting any of these guys in. The Delkamuk decision from 1997 is a decision that came from the Wet'suwet'en and the Gitxsan fights with the government over our lands, and it was those court cases that recognized our title. So that move alone set the stage for the Delkamuk decision, which happened a couple of years ago here in BC, but it also set the stage for other people to stand up and say, hold on, you guys call yourselves a nation state? You're going to have to sit down and start talking with us. You're going to have to listen to what we have to say. Yeah. Those that didn't sign any treaties, like you said, were kind of forced into this confederation called Canada. And in BC here, it's one of the places, Joseph Trutch was one of the earliest politicians that signed on to the Confederation Act. And when he did that, he did it under false terms. He said that the Indian land question was dealt with. And in order for him to join Confederation, he had to make sure that was the case. And all he did was he said, yes, that's the case, and he joined Confederation. When in actual fact it wasn't. That's why there's the BC treaty process here today. Our people aren't treaty people, and the Wet'suwet'en and the Gitxsan took the governments of British Columbia and the government of Canada to court. We didn't have to do that because we already have our own laws, we already have our own system. But we decided to do it to prove that even within their own court systems, we can still beat them.
No.
The whole question of sovereignty isn't about us trying to have our sovereignty recognized under the Canadian court system. Our issue with sovereignty is making sure that we assert our sovereignty. It's our laws, our lands.
Okay, now we talk with Chief Isadore Day, who's a regional chief of the Assembly of First Nations. We get his perspective of what went on this week with a Supreme Court case that's going on with the Chippewas of the Thames who are trying to stop a pipeline. Here's Chief Isadore, AFN Chief Isadore Day.
Okay. All right, so my name is Isadore Day. I'm the Ontario Regional Chief. And this week, the Chippewa of the Thames and other interveners, through their case, brought forward a compelling number of arguments to the Supreme Court of Canada. And what they were talking about was the sense of confusion around who the Crown is and what authority does the National Energy Board have. Are they able to assume, the duty to consult? Can they be judge and jury on issues that come before them with respect to Section 35 rights of our people, Indigenous rights around protecting the land and speaking about their concerns on matters like pipelines? So what Chippewa of the Thames simply done was they said, here's our issues, here's our arguments, and we don't believe that the National Energy Board should have that type of authority, and that we need to approach this from a nation-to-nation perspective with the Crown. When I was at the Supreme Court in support of the Chiefs of Ontario, because we are an organization of chiefs from across Ontario, we have the resources and the ability to pull together information in support of these types of political struggles. And we are formally one of the interveners in the Supreme Court of Canada case brought forward by the Chippewa of the Thames. In my role as the Ontario Regional Chief, my job is simply to make sure that we coordinate this type of activity, this type of support, and that I go to places where chiefs are raising these political issues and these struggles. And certainly at the Supreme Court of Canada, we will continue to support Chippewa of the Thames. Formally in our submission to the Supreme Court in support of the Chippewa of the Thames, but we'll also make sure that we continue to bring our efforts forward in different places that we sit at in support of the Chippewa of the Thames. For example, one of those things is that I currently sit at the AFN table, and I'm the lead on the Environmental Assessment Review, the National Energy Board Review, the Fisheries Act, and the Navigation Protection Act. So, I'm also able to elevate the concerns that the Chippewas and Thames have brought forward at those tables. So, overall, the Chiefs of Ontario, we're honored to support Chief White-Eye and Chippewa and Thames, and we will continue to do so until there's justice served, and until the National Energy Board and the federal government and the Crown get straight and get clear what their relationship is, and the respect for nation to nation upheld.
This was a broadcast from Actions Zaasakwe Online Radio.